SJC-12323, Alyssa Cormier and others, v. City of Lynn and others.
Mr. Sheff, good morning.
Good morning, Your Honor. May it please the Court. Chief Justice Gantz, Honorable Justices of the SJC, I'm Doug Sheff, and with me is Sarah Kahn, representing appellants, Alyssa Cormier, James Mumbauer, and their son Matthew. And I'm here to present two arguments, one that may benefit Matthew, and another that may benefit him along with countless other kids who pass through our public schools. The Brickett School in Lynn instructed Matthew Mumbauer, along with other students, to line up by class, before school, on a particular metal and cement stairway, which he did, when his classmate and known bully pushed him down the stairs, rendering him paralyzed for life. Now, the defendant's motion to dismiss their 12B6 motion should have failed, as the defendants were indeed the original cause of the conditions leading to Mr. Mumbauer's injuries under Chapter 258, Section 10J.
With that interpretation, can't you turn almost anything that's a failure to act or an omission an original cause?
No, Your Honor, and Your Honor states that the law correctly that that should not be allowed to happen. Here we have an affirmative act. We have an instruction by the school to line up on a particular stairway. This is not like Broome, where there wasn't an affirmative act, and it's not like Kent, where there wasn't material contribution. In fact, those two cases comprise the two-pronged analysis, the test that this court has established, an affirmative act which materially contributes to the harmful condition or situation. The school's affirmative act of ordering a before-school, unsupervised lineup on a dangerous stairway where the plaintiff had to be in close proximity with his known bullies is certainly
Let me ask you something.
Yes, sir.
If we have capable and bright lawyers that can craft complaints and take this kind of mile-high view of it, and as Justice always suggests, perhaps turn a failure to do something into an affirmative act, would you have a cause of action if the complaint was that the school decided to place Matthew in the same class as one of his tormentors, Brian? That would be the affirmative act as well?
I just want to understand your question. Just placing him in the school?
Right, so we're talking about what is it that led them to that stairway, right? That's where the harm occurred.
Correct.
From Brian.
Correct.
And I've read your very fine brief and the amicus submissions on the issues of bullying, which we shouldn't pass over. But what I'm trying to get at is, if we have kind of that mile-high view, couldn't a lot of things the school did in this case be construed as affirmative acts? They placed him in the same school, they placed him in the same class. They were on notice that poor Matthew was being tormented for years.
I think that a lot of things could be considered affirmative acts. I think where the law separates out pretty much anything could fly, Your Honor, would be where you get to the material contribution. Here, if you look at the Gennari case, for example.
And then I'm going to ask the other side whether or not that was wrongfully decided. But yeah, and I get the Gennari case which said, well, the decision to have recess with a bunch of little kids in a cement playground is dangerous.
Correct, Your Honor. Ours was even more so of an affirmative act that materially contributed. In Gennari, there were some protruding cement benches, and the kids were told they should have their recess. They were directed to recess in that area. In our case, what happened is our kids were directed to a stairway with many protruding edges, with a slope, at a time where kids are prone to do horseplay. In our case, is stronger than Gennari because, in addition to just directing to an area, as Your Honor made the apt example, just going to a classroom, this was directing Matthew Mumbauer to a stairway amongst his bullies unsupervised. This was, in effect, placing the pit bull next to the poodle.
So if the school had said, Matthew, you're over here, and I don't know, unfortunately, how many bullies were in this class and who was picking on him, but say Brian was the main bully,
Okay.
And they had said, we're going to line them up. Matthew, you're always over here, and Brian, you're always on the other end of the line. And Brian walked over and pushed Matthew. Same issue?
Well, that would be, that would go to the, whether there was negligence, and that would be for the trial court to decide. But perhaps this court would, that would be really a matter of proximity, I guess is what Your Honor is saying. And perhaps if the school did that, maybe there wouldn't be a material cause, but it's a question of proximity, and here we have that close proximity.
And that's what you suggested, Mr. Sheff, is the limit on this. It's the materiality we should look at? What materially...
I believe there's no question it's an affirmative act, so yes, I believe that the question is materiality, and the seminal case, of course, is the Kent case, and our case is so easily distinguished from that case, both in terms of temporal proximity and physical proximity. Look at the Kent case. A parolee is released and commits a crime 8 years later, where Mr. Mumbauer was in the actual process of conforming with the instruction at the precise moment that he was injured. Temporally, it's simultaneous. Look at the physical proximity. In Kent, you had a parolee who was free to roam throughout the United States and Canada. In our case, however, they were assigned not just to the Brickett School or a classroom, but a particular narrow and dangerous stairway in close proximity with his bullies. So I think there isn't an issue on either end. I think we make both prongs of the test. And this case is stronger than Gennari, not like Broom, and not like Kent.
Now, your brother in his or their brief, I think, says they were supervised. The teacher was there. Would that matter? Well, first of all, do you agree that that factually was true?
I believe that it wasn't true and that the record is replete with examples of it not being true. And I understand that it was a 12b6 motion, but as Your Honor knows, you are free, of course, to go beyond the complaint to look at all of the items appearing in the record in this case, as this motion was brought about a month before trial. And so if the court wishes, I could direct you to a whole host of citations through depositions and other sources.
Okay, so you tell us at a minimum there's a material difference of fact as to whether or not there was supervision at that time.
At a minimum, but well, our position is there certainly was no supervision. If there was, somebody would have seen something. Even the bully in this case states that at that time there were no teachers around. So I don't think we have an issue there, Your Honor.
Okay, and help me to understand how the kids were along the staircase in terms of when he was pushed. Were they all going down the staircase?
They were in single file.
Was he at the front? And I'm trying to figure out exactly how
Matthew would always hide in the back, and it was a single file. And as they went up the stairway, any bully who wanted to could turn around and push him, and that's exactly what happened.
They were going up the stairway.
They were lined up the stairway.
And then he was pushed backwards?
Correct, and he fell down the stairs and was eventually paralyzed.
And he was the last one?
One of the last ones, I believe. I can't say for sure. If I may proceed to my second argument. It's our second argument that actually provides this court with an opportunity not just to assist Matthew, but to protect countless children without disturbing Broom or Kent. This argument is simple. In the context of a school bullying case, this court should interpret mandatory attendance as original cause. And it's important to say at the outset, Justices, that we're not in any way deriving this interpretation from any kind of due process or constitutional right. It's not a 14th Amendment or a 1983 case where we did say that mandatory attendance should be looked at in earlier aspects of this case that were stripped away before we got to this limited issue. We are not looking for a special relationship. We are not looking for degree of custody or vulnerability. Rather, simply, an interpretation of Massachusetts statute based upon Massachusetts case law. And as the United States Supreme Court said in DeShaney, states and municipalities are encouraged to develop law and responsibilities for their agents, just so long as it doesn't violate the Constitution. And it doesn't. Let's look at what we have in this case. We have a a pure opportunity to do something good for these kids. I have searched and have found nowhere in American jurisprudence a definition for original causation, leaving the door wide open. The definition of bullying since the 2014 bullying statute has been established gives us a wonderful, neat, concise definition of bullying that you may choose to use in your decision.
Is
Yes.
that beyond the scope of our grant of further appellate review?
Your Honor, I will concede that this is a new argument, but I will urge this court to relax the rules consistent with the Royal Indemnity versus Blakely case, 372 Mass 86, because this is for the public good. This involves many, many millions, potentially, of people besides the parties in this case, and that's when the court should relax the rules. And in addition, there is no case law on it, so my brother shouldn't be prejudiced in that regard. But we understand a few things. We understand that we may have waived it, that's true, that you may choose to use it for this case. You may have already, sua sponte, been thinking about this. This may be some help to the court, I hope. And maybe this is to be used for future cases. But I think it's important to hear the argument, to consider the argument, and that is, of course, up to the court to do.
It's not so easy to say, what's in the public good. The amount of additional teachers and teachers' aides and insurance may be enormously more money than dealing with training and dealing with education and trying to deal with bullying in a different way. It's just not so easy to say, okay, let's increase liability dramatically, and that's in the public good. What's in the public good is to reduce bullying, and it's not really clear without briefs that this is going to accomplish that.
I understand, Justice, but first, we're not disturbing we're not changing or relaxing liability. The case still has to be tried and won in the Superior Court level on its merits. We're not relaxing Broome, and we're not relaxing Kent. And to the other argument about cost, I say this. If it's so expensive to protect the children of Massachusetts, if that is the place that we're at, where we have to cut costs to prevent kids from becoming paralyzed, then I say we're doing something wrong.
But that's not the point. The point is, if we do this, is there going to be less money? It's not whether or not to stop bullying. It's if you're going to make an argument like this without it being briefed, it's what's the best way to stop bullying? And if speech doesn't solve it, I mean, it's a hard question to know without briefing.
Without briefing it.
Yeah.
I can't do more than what we've done. I will say that I believe that schools are not paying attention to this problem to the extent that they would if they knew that they might have liability. And I believe that costs, if that's your question, will actually be reduced because one way or another the Commonwealth's going to pay for this kid.
Isn't that the point that Justice Ireland made in his concurrence?
Exactly.
In Broome
Exactly, Your Honor.
about the protective aspects, and we can consider that when we discuss the immunity.
That's correct, Your Honor. And that goes not only to the very point you made, but to another point. Justice Ireland, in his footnote in the Broome case, passionately implored the legislature to act. But actually, the legislature went silent after that. In fact, I would argue but that was in the context of the Broome case where there was no affirmative action. I would actually argue that not only is the legislature not preventing such a ruling as we're urging, but I would argue that the legislature is encouraging you to do so. In the 2014 bullying statute, first we heard nothing after Broome, from 1999. By 2014, the legislature had a wonderful opportunity to speak, and what did it do? It said that it would not touch existing private causes of action. In other words, this is your province. This is up to the SJC. If anything, the 2014 statute indicates an urgency to protect kids. And they had deferred to you. So really, what you have an opportunity to do here is to use all of those due process cases that just couldn't get us there. It's a rabbit hole. It couldn't get us there. Use all the public policy reflected in those cases. Use all the public policy reflected in the 2014 statute. And do what you are free to do. I believe it would be a monumental, it would be a tremendous thing to do for the kids in this Commonwealth. I think this court it does not shy away from challenges, such as the Goodrich case, for example. That's when this court shines the brightest, and I think this is an incredibly wonderful opportunity for this court to protect kids. They're dying. We can protect them.
Let me just make sure I understand. So for all practical purposes, if we deem the affirmative act to be the mandatory attendance, then any failure to act, any negligent failure to act by a school that fails to prevent bullying would be within the Tort Claims Act.
Yes, Your Honor, because in the context of bullying, mandatory attendance is always original cause. If it's an affirmative act, there isn't even a question about material causation, because the entire school, it's like dropping a guppy into a shark tank. There's no safe corner. If they don't find you in the homeroom, they'll find you in the locker room. And they don't find you there, they find you in the cafeteria. The entire school is what I would call a zone of danger for those kids. So there is material causation, and there is an affirmative act. In the context of bullying, mandatory attendance is original cause.
And you would limit that to the bullying cases, or would you say that in all cases of alleged failure to act school negligence, that mandatory attendance suffices to meet the affirmative act requirement?
Well, we'd love to expand it, Your Honor, and if there was a case, but I think bullying is what we're here to discuss, and certainly that gives the context of a constant notice and so forth, and I think that in the context of bullying cases is the way we'd phrase it.
Okay, thank you. Mr. Lamanna, good morning.
Good morning.
We'll give Mr. Schiff a chance to move out, and we'll give you your full 15.
James Lamanna on behalf of the City of Lynn with Attorney George Markopoulos. Plaintiffs here are seeking to repeal 10J. As you brought up, Judge Gaziano, Justice Ireland in 1997 urged the legislature to change this law, and in their wisdom, they chose not to, and that law remains on the books today. With respect to mandatory attendance, if that's the case, if that's the original cause, we could sue the Commonwealth of Massachusetts as being the cause of Matthew's injuries. I respectfully state.
Was Gennari rightfully decided or wrongfully decided?
That was wrongfully decided in my view. The original cause, just where I went to school, there was an elementary school with concrete.
Well, when we went to school, nobody was in car seats either, so we can't really go there, right?
But the
You were
original
in the
cause
back of the LTD bouncing around, right?
the original cause was the violent and tortious act of the fellow student in that case, not the decision to have it inside, outside, grass, or concrete.
So you don't think we need to reconcile the Gennari or take the mile-high view of causation that's urged?
No, in this case,
Or affirmative act, rather.
in this case, if instead of lining up, the kids were just allowed to come in free for all, and this happened. The original cause, my brother would be arguing, was the fact that we didn't line up. So anything the city does would be crafted as the original cause of the accident. The original cause here is clearly the act of Brian shoving the student down the stairs.
Can we have contributing cause? Can there be more than one original cause?
This is too remote of a cause. There's no evidence in the record that they were told, Brian, you have to be right in front of Matthew. If that was the case, that's a different case. Every kid lined up randomly. And as I stated earlier, if bell rang and everybody ran into the school and Matthew was shoved down the stairs, my brother would be making the argument that that was the original cause and not the decision to line up.
What's the record as far as who told them to line up, in what order they line up, and whether that was a conscious decision made to place Matthew next to Brian?
The record reveals that each class, individual class, would line up together. The teacher would meet them at the door at the time of the bell, and they would, as my brother indicated, walk up the stairs single file. And there was no order, it was not alphabetical order, it wasn't by height, it was by class, and that the teacher would escort the student up the stairs.
And do stairs pose a special risk for precisely this reason?
Well, if the original cause is the fact that Brickett Elementary is 2 stories and not a single story, then might as well, 10J has really got it, and there's no meaning at all to it.
Well, no, if somebody is aware that a kid is being bullied and being bullied by a particular, actually, a step back. Is there evidence that the school knew or the teacher knew that this particular individual was the bully or a bully?
For purposes of summary judgment, the city has to concede that. That's the allegation.
Okay,
The
so-
record would not, at trial would not reveal that.
I mean, again, we're only dealing with issues which are disputed, so I'm not asking you to concede anything, but.
For a motion to dismiss, I have to concede.
But Mr. Schiff then would be in a position to argue, I'm just trying to play it out, so he's better than I am at this, but I assume that he would essentially argue if he gets to trial, they knew that this particular kid was a bully, and by permitting him, without placing him there, by permitting him there to be placing him near the stairs, he put the child in a dangerous position, potentially next to a person who they knew to be a bully, and that, I guess they would argue, would be the affirmative act of putting the child in a position where he is in a dangerous spot, whether it be the top of a slide, whether it be a stairs, whether it be various circumstances where a kid is at greater risk. Would that be enough?
10J was crafted to eliminate the public duty rule. Essentially, what a decision such as that, to Justice Lowy's point, would be required to have probably 1 teacher per student to eyeball the student at all times to make sure that these students are protected.
Well, wouldn't it require more than that? If that's original cause, wouldn't you have to expel the student or be sued?
These are all failure to protect claims that 10J is precisely designed to eliminate and avoid government liability
I
on.
would avoid it.
I'm sorry, Your Honor.
I said there wouldn't be any, maybe there's an obligation to expel if this is going to be put on the city.
Well, for 10J purposes, I would say that the failure to expel the city of Lynn could not be liable for that. That's a failure to protect claim, and that's exactly what 10J was designed to avoid. This 10J was.
But taken to its logical conclusion, you didn't seek to expel somebody who is a bully.
I'm sorry, I didn't.
Taken to its logical conclusion, that's the original cause is you didn't expel somebody who's a bully.
Taken to the fact that their parents procreated the student and had Brian born, that's the reason that this happened. Or the fact that
we do. Let's step back. We do expect schools to protect children from bullying, don't we?
There was an obligation after 2014. That's absolutely correct.
So what does it mean if there is that obligation? If there's an obligation, but there is no liability then for failing to do it?
I would respectfully state that under the 2014 legislation, there is ramifications on individual teachers that fail to protect and prevent bullying. That does not mean that the city of Lynn or any municipality or government is liable. The legislature in 2014 certainly could have taken steps in that legislation saying that if a teacher does not prevent bullying, we're going to put the blame on the municipality for either failing to train them or failing to supervise them. They put the liability in the 2014 legislation directly on the principal or teacher that did not protect the student.
Okay, so you're saying that they essentially imposed this obligation, but they did not choose the remedy of liability as a means to enforce it.
Certainly, that was the opportunity for them, and certainly bullying is an important thing, as you mentioned, Chief Justice, but that was an opportunity where they could put a stamp on it and say municipalities that do not protect students and allow bullying will face consequences under 258, and they chose in their wisdom not to do that. And I would respectfully state that that's the legislative's job to do, is to make the determination what these laws should be and if they should be amended. And it couldn't have been any clearer from Justice Ireland in 1999. He urged the legislature to take action. He did not like that result. And the legislature because recognizing the cost to municipalities and governments in having to, if they were obligated to protect students and obligate to protect citizens, the terrible mass shootings that have occurred recently, to have cities and towns could be held liable for the police for failing to protect, would open up a floodgate of litigation against cities, towns, and states.
Well, the issue, it seems to me that the issue is the best way to stop bullying, the best way to address these issues. And it's not the answer, but the question is hard. Is the best way to expand liability, is the best, and all that goes with that, or is the best way to try and address it someplace else? But I'm concerned with the issue that Chief Justice Gantz raises, which is, well, if you do nothing, where's the incentive? If we do nothing, where's the incentive?
I would say that that's a decision that the legislature should make and balance the pros and cons and costs on whether liability should be expanded. And it's certainly something that's been brought to their attention back, as is indicated from Justice Ireland back in 1999. So it's, when you folks speak, the legislature is aware of it. It is not a decision by a district court or a superior court justice where the legislature would have no idea. They were urged to take action, and they chose not to. So 10J stays on the books. I would respectfully state that this case is very similar to the Brum case in the sense that teachers and principals in that case were warned in advance that the students that weren't attending that school were going to appear, and they were going to retaliate against a student there. So there was actual knowledge in the Brum case that a student was in danger. And nevertheless, the principal and teachers took no action. At least that's the allegations on the motion to dismiss standard. And this court in Brum stated that there is no duty to protect, even when there's actual knowledge. Just as my brother has alleged here that there was actual knowledge that Brian was bullying Matthew. In the Brum case, there was actual knowledge that a group of out-of-town students were going to be retaliating against a student that particular day. They even knew that the day it was going to occur. And the failure to protect claim was rejected under 10J.
So what, if anything, is a school required to do if they know about bullying?
That follows the protocol on Chapter 70, reported to the Department of Education. They're obligated to have a task force, liaisons in school to address bullying, obligated to have seminars and classes, and intervention with bullies. So the 2014 legislation has a detailed obligations on the part of municipalities as far as what they need to do with respect to bullying. And it does not address liability on the part of municipalities, and that seemed to be the appropriate time, if the legislature so desired, to add language in there, putting the liability onus upon municipalities and governmental entities.
All right, thank you.
Thank you.
We'll take our morning break.